And obviously the first couple of paragraphs address the particulars. And so is my understanding correct, um, Mr. Newton, that the last chance agreement wasn't just about what happened on August 13th. It was the event of August 13th happening in the context of in the middle of a performance improvement plan. One of the items or to be addressed or corrected through the performance improvement plan was her professionalism, correct?
Yes.
And the last couple of paragraphs within, I understand they're specific in terms of identifying Ms. Devlin by name and the date. But is that language pretty common in a last chance agreement, putting the employee who's being subject to the last chance agreement what this means?
Yes.
If there's any violation, termination is the absolute next step.
Correct. These were typically given in lieu of termination, because I believe at that point, by the time it was reached here, there was only, I believe, like 3 weeks left maybe of the performance improvement plan, and it wasn't looking like it would be successful. So that's why we issued just the last chance rather than discontinue the PIP and then make that determination then and give her that chance to
Turn things
change
around.
the behavior for the remainder of the PIP. Yes.
Okay. And if we turn to page 2 of the last chance agreement, did you sign this document as the human resources representative?
Yes, I did.
Okay. And did you attend the meeting with Ms. Devlin?
Yes, I did.
And were the terms of the last chance agreement clearly explained to her?
Yes.
And explained such that she should have understood what a violation of the last chance agreement would mean?
Yes.
Okay. So if I can direct your attention to the next tab, R20, Judge Gelhard, this is Exhibit 25. And it's a 2-page email string. I think there was between the KK and Ms. Woodward, but then, and they were August 31st, and then Ms. Woodward had forwarded the email string to you and to Ms. Bailing, correct?
Yes.
So, as I understand, what was being reported to Ms. Woodward is that this KK was reporting that the 1600 group, which was Ms. Devlin's responsibility, wasn't being performed.
Correct.
And is my understanding also correct, sir, that the 1600 group was one of the items in the performance improvement plan?
Yes.
And so you read this email. Do you remember, as of August 31st, reading the email that morning or sometime that day, taking any action?
Yes. I had reached out to Sam Bailing, basically to have her look into the accusation of whether or not the groups were performed, what the validity was. And I believe she interviewed staff, clients, as well as looked at the charting for those groups.
If I can direct your attention, Mr. Newton, to tab R21.
Yep.
And Judge Gelhard, this may be the last new exhibit, but it's a new exhibit, sir.
What number is it?
It's under tab R21.
Okay, let me just get that. And we are at excuse me, exhibit number 28 for the hearing.
Okay, thank you. Mr. Newton, with respect to, so it starts with an email communication from Ms. Bailing to Ms. Devlin on the 31st, asking her to provide information with respect to 3 dates, August 26th, 27th, and 28th. Ms. Devlin responded to her, and then Ms. Bailing forwarded both emails to you. Is that correct?
Yes.
And once you received these two emails from Ms. Bailing, do you remember doing anything, taking any action?
Yes, I had called Sam based on the statements and things that she had gotten. And there was a lot of conflicting statements based on Rachel's email back to her and from what we received from based on the charting, as well as statements from residents and other employees. And I believe it was during that call, I had asked Sam how she wanted to proceed. And I believe it was at that time that she had discussed termination.
Ms. Bailing did.
Yes.
Okay. If I can direct your attention, sir, to tab R23. And Judge Gelhardt, this was previously marked as Exhibit 18.
All right.
Are you there, Mr. Newton?
Yes.
Okay, and this is the report of disciplinary action taken, specifically the termination notice to Ms. Devlin.
Yes.
And it references both the performance improvement plan and the last chance agreement, both of which she was still on as of that date, correct?
Correct.
And so did you prepare this document?
Yes.
And so it's referencing the performance improvement plan, the last chance agreement, and then it's addressing the dates of August 26th and August 28th. Ms. Devlin delegating the 1600 group therapy to subordinate employees without a reason of an emergency. And you state both your PIP and the last chance agreement have specific requirements that you need to complete these group therapy sessions as part of your job duties. And so I know that the meeting was with Ms. Devlin occurred on September 4th, but before that, so just so the record is clear, you prepared this document, and then what was the order of review?
It was reviewed by Kara, then by Chad Weiniger, Director of Administration. It was reviewed by Samantha Bailing. It was reviewed by Corp Counsel and then the County Executive.
And in preparing this document, was there any information that you had seen that the basis for the termination decision was for any unlawful reason?
No.
Was there anything that the decision to terminate was because of Ms. Devlin's use of FMLA leave?
No.
Other employees use FMLA leave, correct?
Yes.
Any concern or any information that the decision to terminate her employment was because of any potential disability?
None whatsoever.
Once you got involved at any, or strike that. I think finally, I think this might be the last. This is the last document. Okay. So if I can ask you, sir, to turn to tab R24, and Judge Gelhard, this is Exhibit 1.
Okay.
And these are notes from a termination meeting between Ms. Devlin, Ms. Bailing, and you on September 4th, correct?
Correct.
These notes, who prepared them?
I typed them as we were meeting.
Okay. And so these notes that are now marked as Exhibit 1, fair to characterize them as contemporaneous notes that you prepared, actually prepared during the meeting itself?
Correct.
With respect to the information Ms. Devlin provided in terms of her answers, were you trying to, was it your attempt or effort to, and I know that nothing's quoted, at least I don't think it is, but record what exactly, in terms of the words that she was using
Yes.
as best you could?
Yes.
Was there any, did she provide any explanation? So during the meeting, how did that meeting progress? What happened?
We began by asking or basically getting a statement again from her, letting her know that based on the statements that Sam had received from other staff and the clients, that the email she had sent to Sam, that she did complete the 1,600 groups on those dates, that we had multiple people that didn't align with what her statement was, and in documentation and in charting and things. So basically it was just to get her final statement to see if she still stood by her statement, or if there was any other information she wanted to give us. But ultimately the decision to terminate was taking place at that meeting.
And did she, in terms of what's recorded as far as the answers, were these pretty much the answers that she gave?
Yes.
I understand that the decision had already been made. The review process had obviously already taken place, right? Because in order for you to have the meeting, everybody that you've described would have had to have reviewed it and approved it in
Correct.
terms of that decision.
Yes.
But did you go into the meeting even knowing the decision was made with kind of an open mind that if she said something, provided a reasonable excuse, an explanation, something that you hadn't considered before, was that one of the purposes of the meeting?
Yes, if there was new documentation that she would have provided or something that she would have given us, that would have shown that her statement and viewpoint was accurate, it would have, the termination wouldn't have taken place, as we would have had to then follow up and verify whatever information was given.
Okay. During the meeting, did Ms. Devlin say anything about, in terms of, well, I delegated on these dates because I was dealing with an emergency? Did she say anything like that to you?
Not that I recall, no.
And not reflected in Exhibit 1?
No.
At any point during the meeting, did Ms. Devlin claim any form of discrimination or harassment?
No.
If she had, would the meeting have continued on, or would it have stopped to allow for an investigation of such a claim?
It would have stopped right away. We would
Okay.
have investigated that immediately.
Before, even though the decision had made, you would have stopped, investigated, and then either stay the course or change course?
Correct. Most likely she would have been placed on maybe like a paid administrative leave while we investigated the claims.
And I know that towards the end of it, sir, there was some discussion, there's some mention of the grievance process. Do you remember how that came up?
Yes, she was reading the termination letter or termination notice, and had asked, I think because on the bottom of each one, it describes it that you can grieve a termination. And I believe that's what she asked about. And I had just let her know that it's the chapter 4, it's our formal process that you can apply for a grievance. And I believe she made some comment to what if she didn't agree with how it went or something along those lines. And I saw that was correct.
Okay. Sir, those are all my questions. Thank you.
Ms. Devlin, this is your opportunity to ask questions of the witness. Do you have any questions for Mr. Newton?
I do. Thank
Go
you.
ahead.
Luke, were you friends with Mandy and Sam outside of work?
Hold on for a second. There was some interference here, and I don't know where that was coming from.
What was that question? I didn't hear that. Sorry.
Luke, were you friends with Mandy and or Sam outside of work?
Outside of work, no, on a professional level, I believe we had met for drinks one time early on, shortly after I had started with Brown County. But personally, no.
Okay. Do you, in all of these documents here, I don't see anything, and then I don't recall ever receiving anything from you where you came to me to ask for clarification on any of these matters. Do you, in any of the things that have been reviewed, did you notice that there were any emails to me regarding any asking about clarification about any of these events?
I'm just going to object to the form of the question, vague over broad.
I'll allow the witness to answer the question. Mr. Newton, your response.
I've met with you as far as like the specific things looking into the 1600 groups or those not being complete. I know that was done by Samantha.
Okay, like, yeah, and then after I submitted my rebuttal to the PIP, I didn't hear anything from anybody. Did you, do you remember ever addressing that or responding to me?
I know that during the performance improvement plan itself, those were many of the statements that you had made during that. And you had even stated like the only thing I do agree with is the 1600 groups. And you were I do recall the meeting where you were confrontational and
Well, the question is, did you respond to her rebuttal statement?
I don't believe I did. I believe when we met at the PIP meeting, I said that she could submit a letter that we would file along with the performance improvement plan, but that the performance improvement plan itself would still be placed in her performance personnel file.
All right. So the answer is no. Next question.
Under tab R24, it's it's the transcript of the termination meeting.
Yes.
Would you agree when you read through this, you never presented to me the option to file a grievance? It's something that I noticed on my own on the sheet.
Correct.
And when I asked, you know, so I said, so you mean like if I don't agree with my termination, I can fight it? And then you said you would have to submit a formal grievance letter and it would be reviewed. Do you ever remember going over any of that with me about what that would entail?
I do not know.
Okay. And I know that you said that the PIP was, I was put on the PIP and part of that was to get me more involved with my supervisor to become more aware of my conduct. Were you aware at that time of the conflict that, like the professional conflict between Mandy and myself?
At that time, I was not, no.
Okay. And in under tab R, and
What was it? R10?
Mandy, R10, yeah, it's BC, it's page BC 105.
Yes.
Mandy stated, she started by saying, here's what I've documented so far. Do you remember being in talks with Mandy prior to that, establishing, trying to establish a pattern or gather enough to initiate a PIP?
Where are you referring to? I'm sorry.
It's at the bottom it's at the bottom. It's Mandy's email to you Monday, June 1st, 2020 at 3:18 p.m.
Mr. Newton, it's under R10.
Do you know
I'm
what
sorry. I'm on R9. I apologize.
No problem.
I've got it now, so.
So when I said when she said here's what I've documented so far, had you been working with Mandy to document a case or a file against me?
No, this is what I had asked Mandy, because she had come to HR with concerns, and we had suggested, based on what some of the behavior she was talking about a possible performance improvement plan. And I had let her know, like, we would need specific documentation of incidents and dates and times. And so I believe that's what she's referring to with what she has documented in that email.
Okay, and so in your response, when you say, I don't think we can use the instance from 2018, what do you mean by the word use?
I mean, we couldn't have that added into the performance improvement plan.
Okay. And then I know you stated that sometimes there would be investigations into, so in regards to tab R5, this was regarding the email that you had gotten from Unum regarding my leave. You said that if there was sometimes reason to suspect that a person was using more than their leave that was allowed, I submitted several calendars, and my leave was allowed to be up to 2 instances a month, and that is as indicated on the paperwork from Unum. And I have calendars from May, June, July, and August. And in each month, there were only 2 instances. In August, there was the 24th and the 25th, but they were
Okay.
counted as one.
Ms. Devlin, you're testifying now. You're only allowed to ask questions. Do you have a question?
I just wanted to ask him if there was something in that prompted him, something besides that prompted him to look into this, because what I'm seeing is that I didn't exceed those. Was there something else that you noted to look
I'm
into
gonna-
this?
I'm going to object to the form of the question. Vague and ambiguous, assumes facts, not evidence. I honestly don't understand the question.
Okay, well, I haven't heard the question yet, so let Ms.
I just
Devlin
wanted to
formulate the
know
question.
what prompted you to look into or to request this under tab R5? You said that sometimes people you'd ask about this. Was there something that I had done in particular that made you ask for this information to try to verify it?
I'm going to object to the form of the question, assumes facts, not in evidence.
I think it's a fair question. Mr. Newton, what prompted you to look into this?
Same objection.
Same answer. Mr. Newton.
This is just a standard email from Unum. I don't recall investigating anything. Like, that's not up to us to determine. If anything, we may look back or have people notify us if they're using FMLA, just so that we can track it to make sure that it's within line, but that's all. I mean, there's
And I know Attorney Nelson had spoken about my attendance, about the levels of discipline. The PIP, but that wasn't included in the PIP, was it?
attendance is addressed separately through like an attendance policy, through progressive discipline that way. Attendance usually isn't something that we as or an employer or a manager or supervisor can assist an employee with.
Okay. I don't have any further questions.
All right. Do you have any redirect for this witness then, Attorney Nelson?
I do. I just want to, sticking on, it's going to be Exhibit 6, so it's under R5. You were asked a question about looking into any, did you look into any, with respect to Exhibit 6, this notice from Megan Winnie at Unum dated August 25th. Were you or anyone at Brown County looking into anything with respect to Ms. Devlin's use of FMLA leave?
No.
Were you investigating her use of FMLA leave?
No.
This is, as I understand your testimony, sir, was this a standard form, whether it's Ms. Devlin or Sue Smith or Joe Jones, any employee who had approved FMLA leave, this is the notice you would receive from Unum?
Correct.
There was nothing different or special about it because it had Rachel Devlin's name on it?
No.
My statement is correct?
Yes.
Okay, no further questions, sir. Thank you.
And Ms. Devlin, do you have any follow-up questions for the witness?
I do now. Thank you.
All right, then Mr. Newton is excused from further testimony. Is that right?
Yes, Judge. Thank you.
Thank you, Mr. Newton.
Thank you.
All right. Any other witnesses for the respondent?
I think I have one other, and it's going to be Samantha Bailing.
Okay. Well, let me just preface this with the, I guess, the guidance that we've gone over a lot of these documents with Ms. Devlin, Ms. Woodward, and now Mr. Newton. And so I guess what I'm not interested in is going over the same documents with Ms. Bailing, just because her name is on the document, because we've gone over them. And for that matter, the documents, Ms. Bailing is going to be the next witness. Go ahead and arrange for her to come into the hearing.
And Judge, and I appreciate you having made that comment. And please give me some indication, because my plan is to simply streamline and just isolate what it is she testifies about, because I understand different people have different roles and different involvement, but I know you don't want to keep seeing these same exhibits over. I get it. And so my approach will be different with her. I want it to be complete, but I also don't want to retread ground that's already been covered.
We won't be doing that, yes.
Yes.
And it looks like Ms. Bailing is on. Ms. Bailing, can you hear me?
Yes, I can.
All right. And if you would please raise your right hand, I'll swear you in for your testimony. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
If you would state your name for the record, spelling your last name.
Samantha Bailing, Behling.
And do you work for Brown County?
I do. Yes.
What is your title?
My present title is Director of Health Services. I was previously employed as the hospital and nursing home administrator.
And when is the last time that you worked as the nursing home administrator?
I'm thinking hard on that one. It would have been the year 2022, I believe February.
Attorney Nelson, questions for your witness.
Thank you. Ms. Bailing, good afternoon. When you held the position of nursing home administrator, what were your principal duties and responsibilities?
My principal duties were to oversee the operations and regulatory compliance of our 16-bed psychiatric hospital, our 63-bed nursing home, and our 15-bed crisis stabilization facility.
The 16-bed facility, what name does it have?
Nicolay Psychiatric Center.
Okay, and the nursing home, the 63-bed nursing home, what name?
That is Bayshore Village, and the crisis stabilization facility is Bay Haven.
Thank you. You know Ms. Devlin?
Yes.
How do you know Ms. Devlin?
Ms. Devlin was employed by Brown County Community Treatment Center, and she worked on Nicolay Psychiatric Center.
We've heard, I'm going to jump around a little bit, Ms. Bailing, because there's been a lot of testimony about a lot of the exhibits. There is a new one, Judge Gelhardt. And it's under tab R7.